you say that this is a mass joinder litigation case then. Um, Go ahead and explain a little bit of what a mass joinder case is versus, say, a class action suit.
I'm glad you asked me that because there's a lot of confusion. People think that if there are 2,000 or 20,000 plaintiffs, it must be a class action. It is not. Let me give you the typical example of a class action case. And we've all seen this because we all get mail, and in the mail we get these notices about class actions. Let's assume that you have a cell phone, and in the small print of the contract of the cell phone, it sets forth the rules as to what the phone company can charge you for and how the charges are levied. And it turns out that on your particular plan, you spoke on the phone for 1 minute and 20 seconds, and the phone company billed you for 2 minutes. You didn't notice that. Nobody does. But as it turns out, through a glitch in their software or a decision that they made, they didn't charge. They overcharged. Some lawyer found it. Some lawyer filed briefs, went into court, brought motions, and at some point, the cellular phone company admitted, "Oops, our bad. We overcharged, and we want to make that right. From now on, we'll fix our software. We'll pay the lawyers $20 million in legal fees, and for all of the people that had a cell phone plan, we'll send them a voucher where they get $1.15 off of their next bill or 10% off the next phone that they buy at a retail outlet." And we get these things. I get them. My mom gets them. Everyone gets these things in the mail. And it says, "Congratulations, you're part of a class action. There's a settlement. The lawyers are making $20 million. If you fill out this form in triplicate and you send it in, then we'll process a voucher for you for $1.15. If you don't want the $1.15, then fill out this other form and opt out so that you'll have the right to sue the cellular phone company yourself for their overcharging." It's a waste of time. The only people that win are the lawyers and the companies that settle out these class actions because they get caught doing something wrong. They fix the problem, which is good, but the consumers get nothing. In a mass joinder case, this isn't about lawyers amassing fees and clients getting nothing. It's about clients getting what's rightfully theirs, what they're entitled to get. Having lawyers fight for the clients rather than lawyers fighting for themselves.
That's a great way to put it. Now, can anybody just join this mass joinder case? What are the qualifications for joining the mass joinder?
Okay. Well, first of all, one has to have a loan with a bank or have had a loan with a bank at some point. There are a lot of people angry at banks, and they may just want to sue the bank just for the sport of it. But these need to be homeowners, and they need to be homeowners that have specific causes of action and rights of recovery against the bank. And we need to look at each of these prospective clients on a case-by-case basis to make certain. And without getting into the technical evaluations, we evaluate the documents to see whether Mears was involved in the transaction. We want to know how the bank was able to come up with the source of funds for the loan, whether the bank actually lent money from its borrowers or pooled money and simply acted as a servicer. There's some technical requirements. Not everyone that wants to join one of our cases can. And if they're not right for the case, we tell them that, and we do our evaluation, tell them that, and wish them well. And many times we can suggest other options for them. There are other people that choose to fight the banks by a bankruptcy and an adversary proceeding, and there are other things that they can do. But for the most part, for homeowners that have obtained loans or refinanced loans in the last 10 years, there's an awfully good chance that they would be qualified, at least for some of the causes of action, in cases that we have pending against their specific lender. There are some lenders that we haven't sued, and there are a number of reasons for that also. So it depends on the lender and the causes of action, whether they're appropriate plaintiffs to join our mass joinder action.
Right.